Welcome to our Workplace Relations Update. With a new federal Labour government in Australia, it's a good time to reflect on recent workplace relations changes and what can be expected moving forward. A number of important changes to casual employment became law in March 21. This includes introducing a definition of what constitutes a casual employee, a casual employment information statement which needs to be provided to all casuals, laws against double dipping of national employment standard entitlements, and major changes to casual conversion rights. The legislation amended the NES to provide casual conversion rights to all casual employees instead of award-covered casuals only. The casual conversion clauses in all awards have been replaced in September last year and refer to the NES now. So, what does this actually mean? An employer must make a written offer of permanent employment if a casual is employed for 12 months and has worked a regular pattern in the last 6 months. However, the employee does not have to make an offer when there are reasonable business grounds not to make that offer, and those reasonable grounds are based on facts that are known or foreseeable at the time of deciding. The High Court has held that the written terms of a contract between the employer and an individual should be the primary factor when determining whether a worker is an employee or a contractor, not the behaviors of the parties afterwards. So the written contract is king. However, a contractor may still be deemed an employee because of the terms in that contract, and the degree of control exercised over the person and the extent to which that person operates an independent business are all relevant. This is consistent with the High Court earlier decision in Rosato, where it was established that contract is king when it comes to determining the employment status. It does not mean that simply writing in a contract that a worker is a contractor is enough. The High Court found that a contractor was still an employee because of the written terms in the contract. It was a labour hire company, not himself, who had the right to determine how and to who he provided his labour, and required him to cooperate in all respects in supplying his labour. The Australian Human Rights Commission released their report into sexual harassment in Australian workplaces back in 2020. The previous government has already adopted some of the 55 recommendations, and they have been put into law. As a result of the Respect at Work report on sexual harassment in Australian workplaces, the Fair Work Commission has been provided with new powers to issue orders to halt conduct, similar to its ability to make anti-bullying orders. In addition, sexual harassment is now serious misconduct within employment law and is therefore reason for instant dismissal. The current government has flagged it will adopt all the other recommendations. It's important to note that this is a relatively new government, so I'm sure there will be lots more to come, especially as a result of the Jobs and Skills Summit. However, there are a few things we already do know. The government will be adopting all the recommendations from the Respect at Work, which includes a positive duty for employers to prevent sexual harassment from happening. The other major point that's coming is paid family and domestic violence leave, which is likely to be law as of February 23. These are the main points for now, and stay tuned for more updates.